Our next guest, someone I think you know very well, Howard Susser of the law firm of Burns and Levenson, a firm that my family's worked with at times in the past. Great firm. Welcome.
Thank you very much. Good morning to you both. Nice to see you, Pat.
Yeah, as always, Howard. Howard, you and I go way back, and so I want to open it up to you because you've been practicing intellectual property law in Boston for many years. So tell us a little bit about what's going on in the Boston legal scene as it relates to intellectual property.
Yeah, so intellectual property litigation, which is mainly what I do, has gone through some major changes over the last decade or more. There have been legislative changes, and there have been changes from law that comes down from the Supreme Court. And it's had a dramatic impact on industries and on the patent litigation industry itself and patent lawyers like myself. The perception 15, 20 years ago was that a lot of bad patents were getting through the patent office. These patents were being used to compel high settlements from big companies because they were very difficult to defeat these cases, very expensive to defeat even a bad case. And there was the growth of this jurisdiction in Texas called the Eastern District of Texas, Marshall in particular, where cases were being brought down there and they were getting something like 80% victories for plaintiffs, whereas that's dramatically over the national numbers elsewhere. And it became a hotbed for small inventors, small companies, also companies in the business of asserting patents, affectionately called patent trolls, or some entities that invested and bought somebody's patents and decided to go sue a bunch of companies to get what they can. So in response to a lot of this, this pendulum swing where the patent system seemed to be in disorder, there's some laws were changed to make it easier to knock out a patent. And some laws were changed to limit the size of damages that a patent owner could ask for, and the type of damages. There was some law was changed to make it easier to go back to the patent office and challenge a patent after you've been sued.
That's called inter partes review, right?
That's correct, Pat.
And so what's going on with that? How do you feel about that as a trial lawyer, as an intellectual property lawyer? Do you think that's a fair shake? Do you think that's a wrong shake? What do you think about inter partes review?
Well, it's the essence of that aspect of the American Invents Act, which became law in 2012, was to provide a vehicle for a party either sued or threatened with a patent to go back to the patent office with prior art, earlier inventions in the public domain, and convince the patent office, who are very skilled examiners of these things, to take the patent back and validate it, that essentially it shouldn't have been issued in the first place from some overworked single examiner down the totem pole. And if the inter partes review petition is granted, and then they're going to take a look at it, that results in a stay of the district court case. And what's born out of that is that there are huge numbers of IPRs have been filed over the last several years, and this court, this quasi-judicial forum in the patent office called the PTAB, has taken on an enormous number, thousands of these cases that were spit out of district court cases. And in something like 60 to 70% of them, they get instituted, which means they end up with a stay in the lawsuit.
And these judges, the PTAB judges, they're not Article III judges, are they?
No, and that's an interesting segue into a very current topic, which is that the Supreme Court just granted certiorari to a case called Oil States Energy Services that's testing the constitutionality of this whole process. And it's quite an interesting angle on it, which is that once the patent is issued by the patent office, it should be now viewed as a property right, a personal property right, like your car.
Right in the Constitution, right? It's one of the few kind of IP is mentioned directly in the Constitution,
it is.
right?
It's in Article 1.
Yeah.
We didn't have to wait for the First Amendment. This is one of the most important things I like to tell people that I do for a living. But the what's interesting is that once you get the patent and it's issued, now you have to go to court and enforce it or license it, and it's no longer regulated by a government agency like FDA continues to regulate drugs and things like that. And so they argue that the ability to take this back to the patent office, something that you've already gotten and used and paid for and maybe fought for, they're taking it back like it's a public right, like this government agency, the patent office has the right to take your property back and invalidate it. And so they're arguing about whether that whole scheme is constitutional. They're also arguing that what happens in the patent office when you get into an IPR is unfair, and that they don't let you amend your patent.
It's not a jury trial. No jury trial.
So it's a Seventh Amendment to get more legal. The argument is that patents traditionally, once they're issued and you go to court, you get a jury trial, and that's to enforce for money damages or to defend with invalidity defenses, such as there's other prior art. And that's how the patent jury trials go that we do. So there's an argument that taking it back to the patent office without a jury violates the Seventh Amendment. It's going to be interesting, but the Supreme Court took it up, so they're going to take a look at it.